welcome to the video lecture for Chapter 9. This chapter focuses exclusively on conducting constitutional searches. So again, we're going to note that search and seizure are going to overlap. So oftentimes, one encounter between an officer and a citizen are going to contain both a search and a seizure. And all of these behaviors are being analyzed under the Fourth Amendment. But there are some foundational rules for searches and seizures. First off, again, there has to be a government actor who's conducting the search. Additionally, the person who is challenging the search has to have standing. So if we think way back to the beginning in Chapter 1, we talked about standing. You have to have occurred some harm that you're challenging. Here, you're challenging the search because it violated your expectation of privacy. So that is the harm you experienced. So under this idea of reasonable expectation of privacy, you both have to have exhibited an actual subjective expectation of privacy. For example, if an officer can stand on the sidewalk and look in your window and observe illegal behaviors, you have not taken subjective steps to protect your privacy. You didn't close the curtains or pull the blinds down. You didn't put something up over the window so somebody couldn't watch you do whatever illegal behaviors. So subjectively, you have to take measures to protect your privacy. You need to put a lock on your phone, things like that. Additionally, we also require that your expectation of privacy is also one that society agrees is reasonable. So for instance, society generally agrees that we should not be like peeping Toms and trying to like get around curtains or we recognize that that's not acceptable behavior. We also, as a society, recognize that cell phones are our private property and we don't let people just come up and use them unless we have someone that we're close to, someone that we share this device with. But a stranger, we don't let strangers just walk up and grab our devices and use them as their own. So society recognizes your desire to have privacy on your devices as reasonable. And these rights are rooted in the Fourth Amendment, but they also are rooted in other amendments that give us some privacy. Now, when a search is conducted, a search is limited in scope. We do not let these generalized, unrestrained searches happen. Remember, if we think back to the Fourth Amendment, for a warrant to be obtained, it has to be particular. So general searches are never acceptable. All searches have to be limited in scope. Searches with a warrant must have probable cause that was sworn by oath or affirmation that particularly described the place to be searched and the persons or things to be seized. So they need to provide the address and location of the home. It needs to be clear whether they're looking for, they're going to be permitted to search one part of the house, the whole house. If it's a home that has a rental property, are they searching the home itself or the rental property? All of these things need to be detailed out in the warrant. Additionally, when officers obtain a search warrant, it needs to be executed in a timely manner. Warrants can go stale, and if it's executed when it's stale, the evidence may not be admissible. While executing the warrant, excessive force is not permitted. There is limited ability to detain occupants of the premises, so they can require that everyone sit and wait in a specific spot under supervision while they conduct the search. Make sure that no one's interfering with the search. Officers can only search the areas where they reasonably believe specified items might be found. If a warrant states that only one item is sought, once it's located, the search needs to end. Now, officers are often protected with qualified immunity. And this is an exemption from civil liabilities for actions performed during the course of their job unless they violate a clearly established constitutional or statutory right. So a gross violation of the Fourth Amendment could qualify for some civil liability, but just conducting a search and staying with the perimeters of the search, officers are going to be immune from a civil suit. Now, while executing this search warrant, officers can also seize any contraband or other evidence of a crime they find during the search with the warrant, even if it's not specified, because remember, contraband is illegal for someone to possess. The contraband does not have to be described in the warrant or related to the crime that the warrant is being executed for under the plain view doctrine. So those are searches with a warrant. There are a lot of searches that occur without a warrant, though. The search warrant is preferred. It is specifically articulated in the text of the Fourth Amendment. Judges review government action before it occurs, but there are searches that can occur without a warrant that are inherently reasonable under the Fourth Amendment. So these searches are consent searches, frisks, plain feel or plain view, searches incident to an arrest, automobile exception, exigent circumstances, open fields, abandoned property, and public places. So thinking back to the last slide, if an officer is executing a warrant and they see drugs and paraphernalia, that is plain view. They are legally allowed to be there and they have seen evidence of a crime. Now, searches with consent. These are the most common type of warrantless search. An officer asks for voluntary consent to search, and if the individual provides it, the officer can do so without a warrant. Any evidence the officer finds would be admissible. The individual can revoke the consent to search at any time. Now, only someone whose constitutional rights may be at issue can give consent. So your neighbor can't give consent to search your apartment. They have no constitutional rights at stake if officers find something in your apartment that you're not supposed to have. And this is important. Fourth Amendment rights are specific to us. We each carry around our own Fourth Amendment rights. Maybe I like to think of it as sometimes as like an umbrella of protection of Fourth Amendment rights. So those rights need to be protected. And it's also the same way. You cannot raise a Fourth Amendment issue that doesn't affect you. Consent to search an individual must be given by the individual itself. Consent to search a home can be given by anyone who has lawful authority over the premises or apparent lawful authority over the premises. Sometimes when people cannot give consent, a landlord cannot give consent to search a tenant's home or apartment. Hotel employees cannot give consent to search the rooms. Only the tenant or the hotel guest can give the consent there. Now, frisks, we'll talk about frisks again. It's a very important part of policing and constitutional law. If an officer suspects someone's armed and dangerous, frisk can be conducted without a warrant. Again, these are limited pat-downs of outer clothing for the officer's safety. Some factors that can contribute to the decision to conduct a frisk are if a suspect flees, officer notices a bulge in the clothing, their hands are concealed in their pockets, or being in a known high crime area and having a reason to suspect that the suspect would likely have a weapon, because with their knowledge that weapons are often used in drug-related offenses in an area that's high crime or well known for drugs or weapons, officers have more reason to suspect that people may be armed. In Minnesota v. Dickerson, 1993, an officer conducted a frisk, and that revealed no weapons, but officers felt a lump in the respondent's jacket pocket. He thought it might be crack cocaine. He examined it with his fingers and then reached into the pocket and retrieved the bag of cocaine. And this was challenged as violating Dickerson's Fourth Amendment rights. And the court said that This search was lawful without a warrant as long as the narcotics are instantly recognizable by plain feel or touch. If you cannot tell right away by just simple touch, then could be a violation of constitutional rights. So ultimately, if officers during a frisk encounter something that they have reason to believe based on their training and experience is contraband, they can seize it during the frisk. Now, plain view is the idea that unconcealed evidence officers see while they are engaged in lawful activity can be seized and admissible in court. If they can look in your window, if you invite them in and they see drugs, all these are scenarios where if they approach your vehicle during a traffic stop and they look in and they see something in the back seat that is contraband, all of those are plain view. Now, they cannot intrude upon your home though. So in Kylo versus United States, officers used infrared technology to take thermal imaging scans of Kylo's home. They determined based on the amount of electricity in the thermal scans that he was likely running a grow operation, and they got a search warrant. And that search was considered a search because they used their technology to look inside someone's home in a way that they could not have done so otherwise. So plain view, engaged in lawful activity where they're allowed to be, would not include like using a telescope or binoculars to try and see something that they could not otherwise see or get on their own. So binoculars maybe is a bad example. I could see binoculars being acceptable in some circumstances based on totality of the circumstances. But technology that's not available to the general public that's being used to look inside somebody's home is generally kind of what this case has been interpreted to mean. Once someone has been arrested, lawfully taken into custody, a search incident to arrest is permitted to occur without a warrant. This is considered necessary for two reasons. One is protect officer safety and remove any contraband. The other is to remove and detect contraband. So officer safety and to recover contraband. This is rooted in two cases from the 1960s, Ch9 versus California, which held that searches incident to arrest must be immediate upon the arrest, and they are limited to an area within the person's wingspan. In this case, it was in Ch9's home, and they searched other places in the other rooms of the home where he was not arrested. And so the court found that it's limited to the individual and the areas that they could reasonably reach. Ch9 versus California, drawing blood absent exigent circumstances is intrusive, and you do need a warrant for that. That has changed a bit over time. There are times where just your body's metabolistic processing of alcohol can be an exigent circumstance. But again, it depends on the totality of the circumstances. Now, the automobile exception is rooted actually in the 1920s, and if government agents have probable cause to think a vehicle has contraband or evidence of a crime, they do not need a warrant to search the vehicle because cars are mobile, and in the time it takes an officer to get a warrant, the car, the driver, the contraband, the evidence could be long gone, and they could cross state lines. They may not ever be accessible again. So again, the next slide kind of details Carroll. He was suspected of alcohol sales during Prohibition. This is Prohibition time, so it violated the Prohibition Act. And they found that because he was suspected of committing a crime, a warrant wasn't necessary for the search of his vehicle. Probable cause to believe the vehicle's contents violated the law, and the vehicle could be gone by the time a search warrant was obtained. Now, let's talk about exigent circumstances. Exigent circumstances are situations that require immediate action from law enforcement to preserve evidence. These circumstances include danger or harm to an officer or another, danger or destruction of evidence, drunk driving or driving under influence of another intoxicant, hot pursuit, including hot pursuit of a fleeing felon, and an individual requires a rescue from law enforcement. All of those are exigent circumstances, so officers could enter a home in order to provide emergency aid to somebody without a warrant. That is an exigent circumstance. So further, plain view has been extended to hold anything held to the public is not protected by the 4th Amendment because no reasonable expectation of privacy exists. Again, remember, very first slide, you have to subjectively protect your privacy. Things that you extend out to the public, like open lands and abandoned property, those things you don't have a subjective expectation of privacy, therefore it's reasonable to search without a warrant. Some other searches that are regular are border searches. These searches of persons, belongings, vehicles at international airports and international borders. They're reasonable the further someone gets from the border, the more that the traditional search and seizure requirements come back into play. And under Montoya de Hernandez, routine searches require no objective justification, so that it is acceptable to search every person who enters or exits. Special needs searches also exist. These are limited searches the court considers reasonable because of societal needs, and the needs of society outweigh an individual expectation. Special needs searches are conducted in prisons of probationers or parolees, drug testing for occupations, administrative searches of closely regulated businesses, community caretaking, and public schools. All of those can operate under special needs. Now, the next couple of slides detail out electronic surveillance. So this is using technology to eavesdrop a person, their luggage, where they live, homes, businesses, even obtaining urine testing or surgically removing a bullet have all been determined to be searches under the 4th Amendment. Physical presence is not required to constitute a search. In each one of these cases, though, you still have a reasonable expectation of privacy, so a warrant is generally required to conduct these types of searches. For example, a fairly recent case, government agents attached a GPS device to somebody's vehicle. They suspected him of drug trafficking, and they tracked the vehicle nonstop for 28 days, and that was found to be excessive, and a warrant was required. Additionally, the suspect was not the only driver of that vehicle. His spouse regularly drove it, so it not only invaded his rights, it invaded the other driver's rights as well. So warrants are generally required for these types of technology, especially like long-term use of technology to surveil. Title III of the Omnibus Crime Control and Safe Streets Act prohibits the interception of phone conversations unless one party consents. So to obtain a wiretap, probable cause that a person is engaging in these types of communications needs to be established, and normal investigational procedures need to have already been tried and not produce the results needed before a warrant should be given for a wiretap. All right, so this wraps up the video lecture for chapter 9, all about searches. For review, definitely want to understand the basic premises of a search with a warrant and all those warrantless exceptions. That's where we spent the bulk of our time this chapter, and it's really important to be able to articulate these exceptions and distinguish them from each other. If you have any questions, feel free to reach out. I look forward to hearing from you.